21 is concerned. So I recommend to you that you read it and read it repeatedly. After putting in so many years at the bar, I read it 3 times in the span of 3 months. It's so interesting that you learn the evolution of law. In these 9 judges, the controversy has been settled, at least till now. You do not know, later another 11 or 13 judges may come and say something else, but for the present, the controversy pertaining to right to privacy, what is the scope of Article 21, it has been sealed. And now it has been clearly stated in these 9 judges, all of them in unison have said that there is a right to privacy which can be exercised by an individual in this country. The arguments that were advanced that right to privacy is not mentioned in the Constitution, court doesn't have the right to read something which is not there in the Constitution as a right that is guaranteed to an individual, all these arguments have been rejected by sound reasons which are well founded in the Constitution itself by the Supreme Court. Now, as it stands, right to privacy is read into Article 21. And what is this right to privacy which I have been speaking of for the past 20 minutes? This right to privacy allows you to be let alone, is the word that I used, to be forgotten, which means that even if you have said something, somebody should not put that against you. You have a right to be forgotten, is something that is being used. In this digital world, the right to be erased is a right that is being spoken of now. Let us now see the development of this right from about 100 years back to now. Initially, the right to privacy was concentrated on right to property. Now, that has shifted in the 1950s from right to property to right of individual. Individuals' rights have come in. When we were speaking of privacy in the homestead days or even in the earlier days of Senai, it was right to your property. You didn't want somebody to come and invade your property, throw you out, interfere with your life. That's your physical property. Now, the right has shifted to a person not pertaining to his property, a person as an individual, and about his thoughts, about his beliefs, about his ideas. These are the rights that are protected now, which are imbued in this right to privacy. Now, the last question would be, how is this going to work out in this digitalized period? Right to information is a right that everybody has in this country. When you are speaking of right to privacy, a completing right is right to information. The tussle has always been whether an individual has a right to privacy, not to be spoken about him, not to be written about him, and on the other hand, of say a celebrity or somebody in public life or any person for that matter of fact saying that what is it that you're speaking about, it's my personal life, and the press saying that I have a right to tell the people about you. The right to speech in 19(1)(a) includes right to dissemination of information and right to receive information. Right to speech doesn't end with me speaking. You all have a right to receive the information if something is written in the newspapers, and right to dissemination of information is also a part of that right. What happens when there are competing interests? There is an interesting discussion in this 9-judge bench, especially by Justice Chalmeshwar in his judgment, where he refers to the dark matter. There are verses coming from Justice Chandrachud and Justice Nariman's judgments where they deal with the silences in the Constitution, which means that something is not mentioned in the Constitution, how do you exercise those rights, etc. As I have already said, please read that judgment. I need not speak more about that judgment. It's how good that is. Now, coming back to this informational privacy, in this digitized world, you must be knowing about the statistics of the use of mobile phones. I think it's about 75% of the people in this country have mobile phones. More than 1 crore of people, 100 crores of people is the number, 1 billion using mobile phones. Justice Newberger from England in 2012 was asked to speak on right to privacy, and he said that the use of internet over the years, that is about 8-year period, has grown from 0.4% of the population in this country to about 46% of the population in the country using internet. I mean, we all become slaves of mobile phones and internet. I see a mobile phone there pointing to me. So I sometimes feel, how did we survive without these mobile phones all these years? It has become a part of our body rather. And so electronics have taken over. Apart from mobile phones, when you are speaking of information, there is a very interesting topic of cloud computing, if you have heard about this. Cloud computing. I hope you understand how cloud computing works. These mobile companies, they have servers, and they store information not in a particular country, but they keep transferring this information to other countries for various reasons. They have their own reasons of cost, they have their own reasons of problems of traffic. So many reasons do they give. And how administration of justice is affected by this cloud computing is a serious topic in USA now. Let us assume that a mobile phone is seized from a criminal. Well, I'll tell you about a case. There's a case, Riley versus California. Judgment of Chief Justice Roberts, who is still the Chief Justice of US Supreme Court. Riley was traveling in a car, and then he was stopped for a traffic violation. And during the course of search, they took his mobile phone. And they just looked at the mobile phone. They were looking at the mobile phone, they found photographs of a car which was used in an offense 3 weeks back. Then they started probing further, and they found this Riley armed with guns, etc., photographs. And then with a little more curiosity, they went further, and then they found that he was a member of a dreaded gang. And they put him inside, and then they tried him for various offences. He has been convicted, appeals dismissed. The matter came to Supreme Court, and then he asserted his Fourth Amendment right, saying that, how can you take my mobile phone without a warrant? You should have got a warrant. Without a warrant, you can't use this. And there is a principle in USA, which fortunately in India it's not there, fortunately or unfortunately it is not there, which is a theory called fruits of a poisonous tree. It all started with judgments of Wolf versus Colorado, Mapp versus Ohio, etc. I will not take you into all those, as a little complicated. But the principle is this, that if you have seized anything pursuant to illegal search that cannot be adduced in evidence in a court, which means the fruits of a poisonous tree cannot be used. In India, that principle is not accepted. There are a number of judgments, Malkhani, Navut, Sandhu, etc. So, you might all now be thinking about what happens of evidence that is illegally obtained by this. Like, you must have heard sting operations. People procuring evidence and then trying to produce it in law. There is absolutely no bar in this country. The only thing that has to be ensured is that there is a section which is section 65B of the Evidence Act, where you have to get a certificate from a person who is an authority working in the telecommunication department or a person who is in charge of the mobile company. Going back again to where we were, in Riley it was decided by Chief Justice Roberts that this mobile phone has become an instrument where every individual stores so much knowledge about him. He takes selfies, he keeps sending them to people, he might be storing personal information, he might be doing e-banking through that, he might be doing e-transactions through that. A whole lot of about the person is there in that mobile phone. So you are invading his right to privacy by looking into this mobile phone without a warrant. Then the question arises from the enforcement agencies, what do we do when dreaded criminals are there? Where do we go? How do we get a warrant? In the meanwhile, there is a good chance that evidence can be erased. Erasure of information is very easy. Then there is a law that was made saying by some states that the mobile companies should find out a method of not erasing, ensuring that this is not erased. They said, okay, we'll get back to you, but we don't want to interfere with the privacy of people. In any event, the mobile company said that we don't have any access to the information on mobile phones once there is a passcode in a mobile phone. Assuming I have a passcode, I just press that passcode and open it. Otherwise, if it is locked, even the mobile phone also doesn't have anything, any information. They will not get any information from that. That's their defense. We do not know how correct it is. And they also say that there is an encryption process which is done, which is impossible for anybody to enter into it. And there is also a decryption process where they delete. So these are all defenses that are taken by them, but the enforcement agencies are not happy. Then a way was found out by saying in the US that you can send an email to a magistrate giving all the facts, asking him to give a warrant. And by email, a warrant is sent by the magistrate on the basis of which we can seize. But the right that is conferred on an individual cannot be taken away only on the ground that he might pose a danger to the security. That is not accepted in the 9 judges bench here, where the right to privacy, which is a part of right to liberty and a right to life, has been unanimously accepted by the court, but it has been said that when it competes with a conflicting interest, especially a compelling interest of the state, then it has to make way. That's the law that is being followed in here. How are we going to ensure that this right is not defeated in this world of digitization? The hearing of Aadhaar is going on. It would not be proper for me to speak about the Aadhaar judgment. But if you think about what has been stated by the 9 judges, and you also think about the privacy in an age of digitization, it is not about how it was 50 years back. It is something else now. There is an argument by persons against right to privacy, saying that if you voluntarily give information, you have an Apple phone, and you have an Apple phone where you give your fingerprint for opening the phone, you follow Google, Google knows where you are going. If you are doing e-transactions, Google knows which bank you are going to, which medical shop you are going to. Now everybody uses only plastic money. Wherever you have paid money, so all these things are revealed to the public. The question then is as to whether you can still say that I have a right, you cannot force me to reveal information. So if that question is posed, then it is possible for somebody to say, I can voluntarily give something which is part of information to the world, but you cannot force me to provide any information. That is the right that I can exercise against the government. I hope I made sense of what I have said. I thank the university for giving me this opportunity and all of you for sitting patiently and hearing. Thank you.
It's very lucid, and you mentioned several cases and judgments. This is a wonderful endowment lecture delivered by Hon'ble Justice Lavu Nageswara Rao. Now it is a time for felicitating our speaker, Chancellor, Lavu Nageswara University. Also request Professor Prakasa Rao, former member of Parliament, Rajya Sabha.
Madam. Sir. Sir, okay. Sir.
Probably students of Andhra University Law College wants to have the blessings of Hon'ble Justice.
Aşağı munduranma. Papa, ma munduranma. Sir, దగ్గర.
Vice Chancellor, Prof Nageswara Rao, highly distinguished and honorable Judge of Supreme Court of India, our Chief Guest, Justice Lavu Nageswara Rao, Principal Dr. B.R. Ambedkar College of Law, Professor Venkata, and highly distinguished guests of the dais, and Vice Chancellor of Dr. Lavu Nageswara Rao University, Professor D.S.Prakasa Rao, and Honorable District Judge, Justice Megar, former member of Parliament, our audience, Padmasri and Bhushan Awadi, Dr. Ambedkar Sir, and members of Dr. B.R. Ambedkar College of Law, and members of Dr. Lavu Nageswara Rao University, members of Bar Council of Visakhapatnam, and other distinguished judges from different courts of Visakhapatnam, press and media, student friends, good morning to all. Today is the happiest occasion, and very fortunate to our young students to hear the views of Honorable Judge of Supreme Court of India. We are very happy to receive him. He is our man from Andhra Pradesh. We are happy to see him and welcome him. And we would like to thank, first of all, Ajahn Venkata for making it possible to bring this great personality to Visakhapatnam. That is why our principal has uncashed it and made it possible to have a lecture in the name of Professor D.S. Raman Endowment lecture. The dynamics of human life, the liberty of human being, and present privacy policy as far as the Indian Constitution is concerned. No doubt there is a conflict between the individual privacy and the government policies. So every individual wants to have a total privacy. As long as an individual, even the persons in the government are also want this type of privacy. once they are in the government and the controlling system, they want to know the privacy of others. That is the problem, that is the conflict. That is why nowadays the conflict of Aadhaar card. Anyhow, we are very happy, sir. I learned many things. Not only myself, the entire student fraternity of Andhra University, as well as the Damodar University people, who are fortunate and learned many things regarding the life of us, liberty which we have and which we want, and the privacy at present, and what we want to have the privacy in future. So most of the times, the development technology has taken over our privacy. I think most of our information are in the hands of mobile organizers, index servers. So whatever it is, we are very happy, sir, for accepting our invitation and coming here and enlightening us. And also we are thankful to all the people which we have mentioned earlier. That is our alumnus VLP garu, Kesara, Jyotibai garu, and other faculty members of Dr. B.R. Ambedkar College and Sanjay Vela College. And also we are thankful to all the student friends and present media for coming and attending and making good exams. Thank you all. Thank you.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा जय 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 हे.
And faculty members can carry a photograph with the permission of Hon'ble Justice.
సార్ కూర్చోండి సార్ కూర్చోండి ఏదైనా కూర్చోండి రండి Sir, study please. Sir, study please. Study. Sir, one more sir. Study. Okay sir.